Hey everyone, Bobby Sawyer here with Johannes Meyer and Sawyer. We're back with our probate and estate planning case study series. Today, we're going to do a little something different. We're going to go over some of the thoughts our clients have after doing an estate planning consultation with us and how we respond to those and kind of talk through whether having a trust or revocable living trust makes good sense for them. Of course, our normal disclaimer: this is for educational purposes only. This is not legal advice. Most likely, I'm not even licensed in your state. And so before you start doing the estate planning process, make sure you're consulting with an attorney, one, who's licensed in your state, and two, focuses on doing estate planning. You really don't want your DUI lawyer doing your trust. Anyway. So, all right. First thought number one, after we go through the estate planning process and discussing what we can do, this seems really expensive. Most people feel that way at first. But when you compare it to the cost of probate, family fights, losing assets to long-term care, the flat fee packages we offer are usually far less expensive in the long run. You're not buying paperwork. You're buying certainty and peace of mind for your family. Just by way of an example, the nationwide cost of probate varies. It varies between 3% and 8% the value of your estate. And so if you have a $500,000 estate, which is really easy to get to if it involves a house, 3% of that is $8,000. 8% of that is $40,000. So you just want to make sure that's kind of the cost benefit analysis there. Number two, reaction that clients have after meeting with us and discussing potentially doing their estate plan: I don't need this right now. I'm still healthy. That's exactly when the smart people act. Once health or memory starts to decline, the options become limited and far more expensive. Instead of a trust-based plan for a few $1,000s, you're looking at putting a guardianship or conservatorship in place, which can exceed $10,000 very easily. Doing it now while you're in control is the easiest and frankly most economical time to do it. All right, number three, I have a will. Isn't that enough? A will is helpful, but it doesn't avoid probate. Your assets still go through court, which means delays, costs, and loss of privacy. A properly funded revocable living trust does what a will cannot. It keeps your family out of probate entirely. Can I just use LegalZoom? Number four, can I just use LegalZoom or an online service? Yeah, you can, but most online plans aren't properly funded and offer zero ongoing support. When problems arise later, there's no one to call. We handle when a client comes to our firm and we do a trust-based plan for them, we handle the documents, funding, family communication, and annual reviews so that the plan actually works when it's needed. Number five, my family will just figure it out when I'm gone. Most families want to do the right thing, but without clear instructions, they often fight or make expensive mistakes. We've seen siblings stop speaking over far less than what you've spent your life building. A good plan removes the confusion before it even starts. Number six, what if my situation changes later? That's why we use revocable living trusts. Revocable means you can change it whenever you want. You can change or revoke the entire plan anytime while you're alive and competent. Our firm, and frankly, I encourage you to go to a firm that does this as well, includes annual reviews at no additional charge so that your plan stays current as life evolves. Number seven, how long does the whole process take? People usually want to not have this sitting out there looming over their head. They want to get it taken care of without a long drawn out process. From our first meeting to a fully signed and funded plan usually takes between 4 to 6 weeks. The documents don't take that long, but the funding requires a few extra steps. The signing appointment itself is about an hour, and then after you pass, a properly funded trust typically allows your family to settle everything in 2 to 3 months, as opposed to 8 months or longer that it would in the probate court. Number eight, do I really need a trust, or is a will enough? If your only goal is to say who gets what, a will may be enough. But if you want to avoid probate, keep things private, protect your family from court, and plan for incapacity, a revocable living trust is always the better choice. What about long-term care or Medicaid? This is where most estate plans fall apart. Without proper planning, Medicaid can take almost everything you own if you need nursing home care. We build asset protection strategies into your trust so you can qualify for benefits while preserving as much as possible for your family. Now, there's a few more details to when and how this strategy works, but it is a very powerful planning strategy. I'm too young for this. Age has very little to do with it. The right time is whenever you own something you want to protect and have people you care about. Waiting until later is how most families end up in probate court wishing they had started sooner. All right, thought number 11. I don't have enough assets. I'm not wealthy enough. You'd be surprised at how many regular families we help. Even a modest estate benefits from avoiding probate, protecting your home, and making things dramatically easier for your loved ones. There is a common misconception that trusts are only for the wealthy or uber wealthy. No, that's not the case. Frankly, if you own a home or a business, and particularly if you have young children, a trust makes a whole bunch of sense. The peace of mind is valuable no matter your estate. Number 12, a common reaction we have from our clients after estate planning consultation: my kids don't get along, they'll fight no matter what. Well, clear, specific instructions in a trust actually reduce fighting by removing ambiguity. We also help you write a family letter or create a short video explaining your decisions in your own words, which often prevents misunderstandings and resentment. Number 13, I want to do this myself. You're welcome to try. However, most DIY plans fail because the assets are never properly transferred into the trust. For example, the properly funded trust means any real estate you own needs to be put into the trust. In most states, that requires an attorney. So if you're having an attorney involved anyway, might as well just have them do the trust as well. We've seen too many families end up in probate anyway because the trust was never funded. We make sure the plan actually works. And then number 14, common reaction or common comments we get from our clients: I already have an attorney or financial advisor. Great. We're happy to work with them. Many attorneys and advisors refer complex and estate Medicaid planning to us because that's what we do. We can coordinate so you get the best of both worlds. And then finally, what if I move to another state later? Our trusts are designed to be portable. We build them so that they work across state lines, and we can help update you or amend the plan if you move. The one thing I will tell you is that anytime a client does move to another state, we typically advise them just to have an estate planning attorney in that state review the plan. Chances are there's no major overhaul that needs to be done. However, if your state treats real estate differently from married couples, then there may be some language that needs to be added. Having a solid foundation now makes any future move much smoother. So there's kind of some insight into what goes through our clients' heads after we meet with them and discuss the trust, the benefits and the pros and cons of using a trust. And on that note, frankly, there really is no downside to using a revocable living trust. There's the initial investment when you put it in place, but moving forward, there's no functional difference about the way you live your life. You pay taxes the same way, you make investments the same way, nothing changes. It's just when you become incapacitated or after you pass away, it makes it much easier for your family to manage things. So this has been Bobby Sawyer with our probate and estate planning case study series. Again, this is for educational purposes only. This is not legal advice. Most likely, I'm not even licensed in your state. Please make sure you consult with an estate planning attorney licensed in your state for your specific situation. Have a great day, and I'll see you on the next one.